Friends, we are going to start now. Today is the 278th Friday group meeting. The topic is Doctrine of State Decisis, Balancing Evolving Societal Needs with Certainty in Dispensation of Justice. Our speaker is Ms. N.S.Nappinai, Senior Advocate. Recently our Supreme Court designated her, and we also felicitated equally. So thank you very much, Nappinai ji. And your earlier also you madam address that is on 16th February 2018, and second time 26th April 2019, and 20th May 2022, and again on 20th August 2024. Your contribution for our Friday Group YouTube channel, 30,000 ladies.
Thank you so much.
So nice of you. Always, 11th hour also you are with us. Thank you. Now.
Thank you so much. Sir, I must remind you, the very first session was in 2017 actually, just before, after my book launch. And I had the privilege of meeting you at that time. And the reason I'm mentioning that is, incidentally, for those of you who may wonder how we decided on this topic, the first book was the reason. So G.Seshagiri Garu and I have been discussing what should be the next topic that I will address the Friday group on, and his strict mandate was no topic on cyber laws. So I was also very happy to do, because we are all lawyers first and then cyber lawyers or any other specialization. So I was also very happy to explore alternatives, and last time I addressed on arbitration, and this time literally Dashami was the reason why I chose this topic, because on Dashami this is a very typical South Indian process where we place our books for puja, and on Dashami we open the books and read. And when I opened Technology Laws Decoded, it opened on the topic on the doctrine of stare decisis. So that's how this session happened, and therefore I just want to share two lines from the book. When I was writing for the book, the whole idea was the book is targeting the younger generation, right? At that time it was still millennials, then we had Gen Z, and now we have Alpha Gen, right? But therefore when I was trying to even decide on the cases I wanted to cover in the book, I tried to choose interesting and captivating cases. And one of my favorites at that time was Justice Kagan of the US Supreme Court. And this was the reason why I became her fan. In one of her cases, she quotes from Spider-Man. Sorry for the spoiler alert, but that's where it is. In this world with great power, there must also come great responsibility. And interestingly, I took this quote, and this was in her judgment in Kimball versus Marvel Entertainment. I took this quote and I changed it slightly to say, in this world with great power, there must also come great responsibility and precedents. And what better way to start off on a topic on doctrine of stare decisis than this, right? So what my book captured was primarily this construct of the doctrine of stare decisis, which provides that today's court should stand by yesterday's decisions. But when and how should it stand by yesterday's decision? Are decisions of courts etched in concrete that we believe that it should not be modified at all, or do we change with the times such that we evolve judicial precedents? So the interplay of first and foremost, the relevance of precedents, how it impacts not just our everyday practice, but also people's everyday lives. What is the certainty that we give to people when we are speaking about certainty in the dispensation of justice? Again, when we were discussing the topic, I told Seshagiri Raoji I would rather lean towards the choice of justice than just law, because I always believe that our dharmic constructs stand way above even just the dispensation of rule of law, and we have evolved our case laws also with this dharmic construct in mind. And with that, let's move into a little bit of the stare decisis topic per se. As I already mentioned, the term, as it says, as I just mentioned itself, is to stand by decisions and not disturb settled matters. It's a foundational doctrine, and if Alpha Gen were here, they would call this the OG version, right? The original version. Koch says it in a very interesting classic English way, and he says those things which have been so often adjudged ought to rest in peace. I love that thing of just let it rest in peace, right? And therefore, I decided to do something that is one of my favorite, topics of technology. So why not ask generative AI, what would an alpha gen say about the doctrine of stare decisis? And here is a very simple way of explaining it. Let us stick to what was decided before, right? And in today's session, I'd also want to cover when and how. And again, what an alpha gen will probably say if they were here is, when and how should this rigidity in terms of merely following precedents, when should it be when should it be relaxed, right? Why should it be relaxed? In what manner should a court approach this thought of relaxation or modification? When do you digress, and is it always good for us? So this is broadly what today's journey is expected to cover, right? So moving forward, there are two ways one could delineate this doctrine of stare decisis. The first is vertical, meaning you have the Supreme Court giving out judgments, and mandatorily it has to be followed by all the courts which form part of the hierarchy. All courts falling below the Supreme Court has to follow Supreme Court's edicts, right, or judgments. Now what happens when it is horizontal? Because when you speak about the Supreme Court itself, then one could say that the doctrine applies in a horizontal manner. This is so when we speak about the high courts also. Again, this construct of horizontal versus vertical will be applicable when we speak about high court as a court of record, where the high court's decisions will apply to all subordinate courts. But when it comes to horizontal application, be it the Supreme Court or the High Court, within the same court, it would apply to equal or smaller benches as a mandatory application. But where an equal sized bench believes that this is a judgment which may not be appropriate for implementation or continuation, then they would refer that judgment to a larger bench and would then seek a modification or an affirmation. All of this may seem rather basic for practitioners like us and what I call as old bandicoots, but it's really critical to lay the foundation to explain where we go going forward, right? So why do I think that it's important to lay down this foundation? You have a catena of judgments now which have come between just 2025 and 2024, which expresses the Supreme Court's angst when high courts do not follow their judgments, where high courts have almost gone out on a limb to question the why a Supreme Court's decision should be applied. And the then CJI of India had to remind the High Court judges that they are not lords sitting in judgment, but they are persons who are there to render service, right? And some of these judgments, the very first one, which is the latest one of 2025 from the Supreme Court, Rohan Vijay Nahar, and rest assured, I'm sharing the entire list of judgments, so just relax and enjoy the session today. I just requested Seshagiri Rao sir not to spoil the surprise elements that may come through the session, and that he can share it immediately after my session. So it's already in his hand, the list. So the first one is Rohan Vijay Nahar was a state of Maharashtra, where a two-judge bench talked about how judicial discipline should be maintained. Certainty and the assurance that an earlier precedent of the Supreme Court will be applied by the lower courts, particularly high courts and below, is something that people should be confident about. If there is no such certainty, then there would be chaos. And this court relies not just on Article 141, which clearly holds that the law declared by the Supreme Court is binding on all courts, but also goes on to rely on 144, which gives the supervisory jurisdiction to the Supreme Court over subordinate courts. And it goes on, just to paraphrase 144 itself, that civil and judicial authorities need to act in aid of the Supreme Court. And that's the first part. But in a very interesting decision in terms of Ratilal Javeri Bhai Parmar was a state of Gujarat, and that's from 2024. The Supreme Court judges call themselves the big brothers. And they say that if we are speaking about the Supreme Court and the High Court as courts of record and people who are laying down precedent law, the Supreme Court is the big brother. And therefore the younger brother needs to follow. And they again express in no uncertain terms their angst about, consistent violation of Supreme Court decisions and the need for it to be implemented. On an aside here, there are no less than 2 judgments from the Supreme Court which have not just been missed out for implementation by maybe other courts, but definitely by the authorities who are meant to implement it. One of the scariest and the saddest one is Shreya Singhal versus Union of India, which struck down Section 66A in 2015. The number of instances that it has been applied, or should I say misapplied, thereafter, that warranted the Supreme Court to intervene again in the PUCL judgment of 2018 is stark in showing how, though we talk today about the doctrine of stare decisis and the relevance of continuing the judgments, the first leg actually becomes the implementation of the judgment. That certainty that if a Supreme Court has delivered a judgment, whatever your opinion may be personally, it will be implemented. Secondly, and this is where the courts kind of came out heavily in the state of Maharashtra judgment, and said that it does not matter what your personal issues may be. You cannot allow that to intervene in deciding a case. You would still have to apply law that has been decided. And that's the criticality there. And in Ratilal, the court relies on Tirupati Balaji developers of 2004. I've just added that here to show that it's not like courts have had to emphasize on the doctrine of stare decisis from only these recent times, but it is for a very long time when they have spoken about it. We will be going back to some fairly old judgments also today, just to trace the genesis and how courts have dealt with this. I was told when I was grabbing a coffee just before coming here that one of the courts actually raised this issue today in the context of a bail petition. We do have a repeated number of cases which talk about bail and not jail. But at the same time, there is flexibility that is being exercised by courts in the facts and circumstances of the case on whether bail should be an automatic dispensation or whether it should still flow from the necessities of, or bases the case which is before the court. And that may in a way be the right approach, and some of the findings itself which I'll be relying on may point to that going forward. And the case that caught my eye first, and believe me, it is not Keshwanand Bharati, it is not the usual suspects that you may wonder about, but it is Vaman Rao. Of course, Vaman Rao has its genesis itself from Keshwanand Bharati, where it laid down the deadline or the date from when the Keshwanand Bharati decision will apply prospectively. So one of the first cases which talked about prospective overruling, I'll be relying on it while talking about what happens when precedents are appended also, and the relevance of relying on this doctrine of prospective overruling to again ensure certainty and consistency in justice dispensation. But going back to Vaman Rao, it goes back to Genesis. And that's why I decided to rely on that first before the local cases itself for explaining the UK and the USA position as a bit of a primer before we move to India. We do love drawing from UK, don't we? And this stare decisis doctrine itself comes to us from the British era, right? We did not really have this construct because we were fragmented. You needed a collation into a centric whole, and you needed a hierarchy, and critically, and that's why it is important for current generation to know the relevance of this doctrine, because it has its genesis from the ability to record judgments and the ability to retract them or retrace them to be able to apply them. And in our today's world of having case finders and easily available and accessible tools to know what the cases that have been decided are and how should it be applied going forward, and more so when we are talking about AI and courts, I think this doctrine becomes really critical, because just pause for a minute here and think about what are we speaking about when we talk about AI in courts. We are talking about AI using that learning, AI and ML learning to be able to read existing laws and reapplying them in an unbiased manner, right? So what else is it but a simple way of talking about the doctrine of stare decisis, right? But again, I'll be closing out with the construct of AI later, and why it would be very dangerous for us to rely only on such tools, and why human intervention is always going to be relevant. But let's move forward first with the UK situation. So the first and foremost thing what they say is, UK relied on this construct primarily because of common law, and also in a way because of its colonial past, where many regions actually resisted the application of UK decisions there, and therefore the doctrine of stare decisis became a nice backdoor for them to be able to implement the decisions from their Privy Council, let's say, or their processes onto the colonial jurisdictions, which may have their own laws and therefore would have some resistance. By saying or making it normative, by saying this is the right way to go about it, you must follow law already established, it became much simpler for them to implement it, and this is what in a way Vaman Rao captures. I've given one reading material also for you all to read if you're interested on a much more elaborate enunciation with respect to the UK background. I wanted to focus a bit more on USA today, more so because of one of the most controversial appending of settled law that happened recently for USA. But let me go back to a little bit in terms of the US construct. It is the doctrine of stare decisis is very much rooted in the American jurisprudence too. It is not necessarily only a dispensation from UK. They have evolved it fairly well. But it's a very interesting way how it moves forward. And the two judgments from Justice Brandeis is actually a classic example of how we also may be facing this dilemma in terms of whether we are supposed to merely apply law as it exists or evolve it or sometimes overturn it too, right? So Brandeis goes on to say, stare decisis is a wise policy because in most matters it is important that the applicable rule of law be settled rather than be settled right. Whereas if you look at, I am jumping the gun a little bit here, if you look at why after, if I'm not mistaken, nearly 28 years later, ADM Jabalpur was overturned, the court said it is important to be right than to just go by settled law, right? I'm not quoting here, I'm just giving you the principle behind the overruling. So this is Brandeis in Burnett versus Colorado Oil. Then he goes on, however, in another judgment to change his position predominantly, I would say, to the opposite end of the spectrum. And he says, stare decisis is ordinarily a wise rule of action, but it is not a universal, inexorable command. That it has been overturned and utilized multiple times, to change existing law is substantial. So the same person who said, it's okay if you don't, if you're not right, but let's stick to decided cases, went on to understand that it is not an inexorable command. This construct of inexorable command, unfortunately, was misapplied, I would say, in overturning a very critical settled position in the US. I'll come to that last. But there is a bit of a journey here which is actually very relevant for us when we look at some of our Indian case laws here. So Justice William Douglas says in New York versus United States, wise policy to restrict the principle of stare decisis to those areas of law where correction can be by legislation is advisable. So what he says is that which only legislature should be doing, maybe you shouldn't be trying to do through changing law. Leave it to them. But where you need to step in, and this is what he goes on to say, if you're going to freeze law as it stands, then the Constitution loses the flexibility which is otherwise necessary to serve the needs of successive generations. So where do our successive generations see themselves? And that's why I started off with the alpha gen to show that if you were to ask them, follow the same thing that your grandmothers did, or follow the same processes that your seniors do, they will ask a very simple question, why? Again, if we were to go back to Sanskrit, the most loaded judgment is ka, or why, in judgment. And they say that one word ka resulted in evolution of so many theories and constructs. So when new generations are going to question why an existing law as a precedent law should prevail over evolving situations, requirements and necessities, that's when you start questioning, is this something that should be left to a legislation or should a court relook it? Moving forward, in Justice Benjamin Cardozo's words in McPherson versus Baker Motor, he says that precedents drawn from the days of travel by stagecoach do not fit the conditions of travel today. There is a beautiful case law from Supreme Court of India also, which talks about how, do we have to freeze ourselves and not change with the change in times, not keep pace with society, not adapt to evolving technologies, or should we evolve ourselves? And in a way that captures the stagecoach construct too. And I now come to the controversial part. And I'm sure all of you all already guessed where I was going. Indeed, I'm talking about the Roe versus Wade situation. We had Roe versus Wade, which actually set right women rights in the US by holding the right to abortion as a constitutional right for women. And this was affirmed by the Planned Parenthood versus Casey judgment. But the court went on in 2022 to overturn these two settled case laws and held in Dobbs versus Jackson Women's Health Organization, that this right of abortion is not a constitutional right of women. It was such a regressive step, and unfortunately it still continues without it being reviewed either through legislative intervention, which is not going to happen in the US, or through further larger benches. Now, with that introduction, let's move into the few categories I've chosen. Clearly, this session cannot be a comprehensive capturing of everything that happens in this doctrine of stare decisis. It's meant to be obviously a teaser round, which will give you an idea of how the doctrine works and where we can contribute to its evolution. Right? We are already contributing, but we need to do a lot more too, and that's probably what I'll be closing out with. So the first thing I chose was precedents per se, and the best thing I thought I could address in that is precedents which were harbingers of change. I'll sprint a little bit here so that I can capture the last part of my session faster. So the first one I chose as a funny anecdote was Avik Sarkar versus State of West Bengal. For those of you who remember even today the Hicklin test, Lady Chatterley's lover and the obscenity test, right? Imagine living with it today. Thank heavens for Avik Sarkar that it moved us to the community standards test. Then you have the Shaira Bano case, it's a triple talaq. Again, something that looked much more progressive, and it's a matter of great pride that India has been looking again and again at evolutionary and progressive decisions and decision making, and we've already seen one from the western side where it did not really live up to that promise, right? And in a way, Puttaswamy has laid the ground for a lot more to happen going forward. Puttaswamy ensured that it would establish not just the right of privacy, but also the right of autonomy of persons to their persona, to their identities, to their bodies. And that's where the women rights and abortion also could probably tie in. So there is so much more to Puttaswamy than just the right to privacy. And it is being explored already, and we'll see a few cases on that. But before we jump the gun to Puttaswamy, I have a few more interesting cases in just the harbingers of change. MC Mehta caught my attention. We all know MC Mehta on the environmental, case precedent evolution, right? But this is a 1987 one of this series, which actually laid down the basis for absolute liability as opposed to strict liability. Strict liability, contrary to what you may perceive it to be, still gives you certain exemptions, which is if you have taken reasonable care, if an fiasco occurs in spite of your best intent or due diligence, etc. But absolute liability, and what MC Mehta laid down was that when you are an enterprise who is involved in hazardous production, when you are dealing in a dangerous industry, then your liability is absolute, and you cannot shy away from liability on the basis that you took reasonable care and caution, etc. And therefore, I thought it warranted a space here. The Nalsa judgment for transgender rights, the common cause judgment on euthanasia and dignified death, and the Babita Punya case were all something that were very close to my heart, and therefore I wanted to place it out here. And yes, of course, Babita Punya, which finally gave women their permanent commission and which recognizes the necessity to treat them as equals, right? That was a great first step there. But a little bit of a step back, and that's why I added some of those judgments from the US courts too. Vishaka versus State of Rajasthan. And what we talked about is let things be until a legislature intervenes, right? And Vishaka turns it on its head to say, where the legislature has not been, let us now lay down certain ground rules. And therefore, it warranted a critical mention in terms of a precedent that is, that brought about change for us. And of course, it gave us the legislation thereafter. in terms of settled law which has been overruled. And this we come to the crux of the session today. I start with the Maneka Gandhi case and the establishment of the Golden Triangle rule. And you know the number of cases that have come thereafter thanks to this Maneka Gandhi's Golden Triangle rule of reading Article 14, 19 and 21 together. And that is therefore a worthy case of mention, and of course it overruled A.K. Gopalan in that. And here again, the next one I have listed, needless to add, was Puttaswamy, and the particular overruling it did of ADM Jabalpur. I have to tell you this a little bit, a small story on an aside. One of my most treasured gifts from my senior was a 1960s edition of Seerwai's Constitution of India. And the first thing, again, see, I've been very lucky when I do that book play, you know. You just open a book on any page and start reading. You never know. It's like an adventure. It's like a treasure trail. You never know what you'll land up with. And I did that with that. It's a 6-volume series. I opened it to the habeas corpus case. So the very first thing I've read from Seerwai's 60s edition of Constitution was the habeas corpus case. And it's really worthy of reading because it's so critical. It is to the point and straight in terms of how the habeas corpus case or the ADM Jabalpur case harms the rights of every Indian citizen. Imagine a world where you cannot claim your fundamental rights merely because an emergency situation has been declared, right? And overturning that, therefore, I would say, was one of the most important steps that Puttaswamy took. Navteej Singh Johar overturning the 377 earlier decision to hold that same-sex relationships between consensual adults should not be criminalized, and decriminalizing section 377 was critical. Again, on an aside, one aspect of it was left to legislative action, which is, if you believe it to be necessary, criminalize non-consensual relationships, even if it is within a same-sex relationship. Unfortunately, that part of it has been missed out in the Bharatiya Nyaya Sanhita, and this is one thing which I feel it really needs a relook on. When the BNS came out, a lot of us had a lot of hope. One of the things was that it's not about reintroducing 377, but about making certain offenses non-gendered, such as rape, right? If you had made rape non-gendered, you did not need a separate provision to make non-consensual violations, even in a same-sex relationship, as a separate offense. So relooking some of those provisions which came in after the Verma Committee and as gendered provisions into non-gendered or neutral gendered provisions is a criticality we will still have to wait for. Joseph Shine, again I'll take a small step back to tell you all, this was 1995, if I'm not mistaken. That was the Jayachandra Reddy Committee, which was organized for reevaluating criminal reforms. And they, Justice Jayachandra Reddy travelled from state to state to have consultations, and also we submitted reports. I was practicing before the Madras High Court then, and I was probably, naturally, I'm talking about 1995 if I'm not mistaken, 94 or 95. I was probably the youngest member in the room also, not probably, I was, and definitely the only lady in the room. And everyone spoke about 497 and said, why should only the husband be punished? The wife or the lady should also be punished. The lone lady in the room was the only one who said, why should anybody be punished? Because it's a consensual relationship between adults. Why don't you let them decide? There are other alternate remedies for either saving a relationship or closing it out because of an adulterous, illicit affair or whatever you may want to call it, but why criminalize it? And it was part of our report also. So I must tell you that was a wonderful foray and my first foray into contributing to policy making, and therefore I was truly grateful when Joseph Shine came out decriminalizing adultery. I'm taking a little bit of a diversion here into arbitration laws. Bharat Aluminium, which clearly held that Part 1 of the Arbitration Act will only apply for domestic arbitrations, wherever it may be held. That was another criticality, not just because of what it decided. And that judgment resulted in an amendment to the Arbitration Act too. But the criticality again was it introduced or reiterated the necessity for prospective overruling. Because it was talking about two judgments, Bhatia International and Venture Global. We had done so many sessions during that interregnum phase on what should be your approach to Part 1. In fact, I would have been very happy if we had a carve out for some protective measure akin to Section 9, even for international commercial arbitrations, because there is a lot of concern that people have, be they corporates or individuals, when they submit themselves to international commercial arbitrations on what would be the approach when they seek interim reliefs, right? So a carve out may have been good, but this certainty that Bharat Aluminium brought, or the Balco judgment brought, was a criticality, but most importantly of prospective overruling. There were so many other judgments which overruled much later an established judgment but did not opt for prospective overruling. And that became a grave concern, especially when it came to criminal prosecutions already launched on the basis of existing precedent law. I'm referring in particular to the Navjot Sandhu case. I'll come to it under a different category later. Adalat Prasad was again a very interesting case which I really love to bring up from my old time days of criminal law practice. Of course, it's Supreme Court has given me the opportunity to come circle back to my first love in law, criminal practice. And Adalat Prasad again was an important decision which overturned a very old judgment of K.M. Matthews, which said that the magistrate who is issuing a summons cannot recall his own summons. You necessarily have to take the route of a quashing petition, right? And we move forward. The precedent judicial seesaw. What better than Keshwanand Bharti to decide on, right? You had first a very rigid stand that Sajjan Singh and Shankari Prasad took, which Golaknath reversed to say that Parliament cannot interfere with the Constitution. And Keshwanand Bharti brought about this basic structure construct. But I would challenge anyone in this room who says they understand this judgment thoroughly and completely. You know, I was in one arbitration and I'm with, I hope Justice Sri Krishna will forgive me for using this illustration. But I was in this arbitration where we were then, I was submitting a 3-judge bench, full bench judgment of the Bombay High Court. And in his typical, humorous vein, Justice Sri Krishna mentioned that Nappinai, until now I was Sri Krishna. But now I don't know whether I'm Sri Krishna or Arjuna, because this judgment, until I read this judgment, I thought I understood what the Arbitration Act mandated very clearly, but this seems to be confusing me more than, clearing the air. But why I remembered that was I was presented with the Bhagavad Gita just before this session. So, sir, thank you for reminding me of this instance. So, in Keshwanand Bharti, when they laid down the basic structure, what I really wanted to focus on today was the political scenario then. The necessity to clarify that our fundamental rights cannot be tampered with, but at the same time balancing the fact that you may need certain amendments, but that which Parliament can do has to be done only in the manner that is set down. Right? It cannot go beyond that to tamper arbitrarily with the Constitution. And therefore today we speak about the Constitution as a living document, and that also reminds us of one of the earlier quotes from the US courts, that's another reason I chose that, which said otherwise our Constitution will just decay and freeze, right? And it will get atrophied. So therefore probably there is some substance to the way Keshwanand Bharti approached it. But there is always that sense that maybe they stop short somewhere. And we therefore rely on the evolving case laws that come forth, and that's why I told you Puttaswamy goes way beyond the right of privacy. It not only took the relevance of the golden triangle from Maneka Gandhi forward, but it laid down so many other constructs which is going to pave the way for some of the cases that are still pending judicial review, which I'll touch upon in the last part. Again, swinging back to arbitration and to the swing of, see here, we spoke about a change which happened over a period of time in Keshwan and Bharti. In interplay between arbitration agreements under the Arbitration and Conciliation Act and the Stamp Act, the court had to intervene to overturn judgments, especially NN Global, which said that without stamping, you cannot rely on arbitration agreements. In today's world, where you have otherwise held that an arbitration agreement which is even captured in an email can be relied on, to merely throw it away merely because it's unstamped, and where law sufficiently gives you leeway to stamp to it is a remedial defect, to just merely throw out an arbitration process on this technical basis does not really help in the dispensation of justice. More so when processes are moving towards alternate dispute resolution. And therefore the interplay judgment becomes critical to understand why so-called settled law was reversed, and within a very short period of time. We will be talking about even shorter periods. I kept the most controversial to last. So moving forward, and believe me, this I don't think is controversial. I've placed it here in the presidential reference case. It was a very short period of time where the clarification has come in terms of what are the governor's rights and whether timelines can be dictated or mandated for return of bills or for a response on it. And I refer, of course, to the state of Tamil Nadu versus Governor of Tamil Nadu case. So we move forward, and of course, as a perfect segue to the next section, which I have said is the short shelf life of precedents. And you know which one is coming now, and this is the Kridai and the Vanashakti case. And the issue here, and you know, this is not a session about standing in critique of judgments that have been passed. The session today is only to understand what plays on a court's mind when it overrules a judgment, particularly within a very short period of time, and the rationale behind the judgment that has been set out. So in the Kridai judgment, what the two-judge majority holds is that environment protection is essential. Environment clearance is mandatory, and we are only talking about legitimate projects which otherwise would have been entitled to that environment clearance. But where it may be merely a technicality that the environment clearance has been missed out, then we should probably try and save the project and not take such a rigid stand that the entire project itself has to be demolished and reconstructed on a technicality. So the issue here will be who decides what is a technicality and what is a material violation of the prior environment clearance that is mandated. So was Vanashakti so rigid that it only resulted in demolition of projects, or did we need this leeway which again gives discretion to the court to decide what should or should not be an ex post facto approval, right? I will stop with this, and I'll be happy to take questions on this or any of the other subjects. We are almost coming to the end of the line here, and this is where I talk about my favorite part, which is precedents which necessarily have to be relooked and hopefully not just overturned, but you know what we talked about earlier, where legislation has either left a vacuum or legislation has fallen short or made an error, then you need to step in. And I go back to one of my favorite topics here of electronic evidence. So the way the Bharatiya, the Sakshya Adhiniyam, BSA, has come out with the alternative to section 65A and B, completely ignores the crux of the judgment in Arjun Pandit Rao. The court went with Anwar versus Bashir, but it did not say that that is the right way to go. It did not say that you must insist on a certificate if the law is changed. In no uncertain terms, please go back and read the Arjun Pandit Rao judgment. I did write a critique on that, and it must be available on my website cybersathi.org. You could probably go and look at it there. I'm sorry I forgot to put that link here. I'll add it later and share it. But what Arjun Pandit Rao said was, please look at the genesis of section 65A and B. You drew it from a civil and a criminal provision under the UK laws. In 1999, UK repealed those two provisions. So why have we introduced a certificate process? You could consider through legislative intervention doing away with the certificate. But what did the legislature do under section 63 BSA? They not only retained section 65A and B, but introduced another layer of a certificate from the person who owns or is in control of a device, and a certificate from an expert. In today's world, when every litigation relies on electronic evidence, today we are talking about digital arrests and the harms it causes and what are the remedies we could evolve. Imagine critical electronic evidence being thrown out because it could not meet the threshold of section 63. So, Arjun Pandit Rao does not need to be overturned, but section 63 may have to be repealed. And therefore, I am emphasizing this in the precedents that need to be reviewed part. And one more aspect when you're talking about overruling of precedents is when a judgment is per incuriam. I wanted to emphasize that too when we are talking about the doctrine of stare decisis here. When Anwar versus Bashir evaluated the correctness of Navjot Sandhu, and it did so 10 years later. And this is why I mentioned this case for the necessity of prospective overruling, which they did not adapt. Anwar versus Bashir said that Navjot Sandhu was per incuriam. In Arjun Pandit Rao, again, they also relied on that for Tommaso Bruno, because within a month or so of Anwar versus Bashir coming out, and where one of the judges was also common between the two, Tommaso Bruno made a mistake in going the other way to say a certificate is not needed. So, per incuriam is another basis where established precedents can also be overturned, and Anwar versus Bashir did that. I may not be happy with the fact that they insisted on the certificate, but when the legislative intent is clear that you must submit a certificate, that a court applies that legislative intent whilst deciding a case is the mandate for courts. And therefore, in that sense, Anwar versus Bashir did the right thing. The outcome may not really help us, but that is the way the law works, right? And what can we look forward to? And that's why I critically mentioned the Puttaswamy judgment. One is the same-sex marriage decision, Supriyo Chakrabarti and another. See, I won't say that the majority decision was wrong, because all they said, and again, therefore, we go back to Justice William Douglas's case. What should be left to the legislature, maybe we should leave it there and stick to settled laws. But where we need to intervene, we may have to. And in Supriyo, the courts believe these are things to be decided by the legislature. Considering the vast gamut of legislations that will be impacted on a decision with respect to same-sex marriages. But the one thing the courts definitely can and should relook and decide on, more so with conflicting judgments coming from high courts, and it's pending before the Supreme Court, is the marital rape exception. The issue before the court is fair. How do you decide a marital rape exception in cases which are between, otherwise, as we talked about earlier, consensual adults? But merely because a particular harm may be difficult to prove, it cannot stop law from protecting the victims. It did not stop the law from introducing a 498A. This is an aggravated form of 498A. So therefore, carving out exceptions has to be a balance with individual rights, and this is where Puttaswamy is going to play a very critical role in deciding the autonomy of a lady's, persona, her person, her decision to do what she believes is right, as opposed to what one of the courts, the dissenting order in the Delhi High Court's judgment, which talks about preserving the foundational aspect of marriage. So, this is going to be a very interesting part. I think Mr. Seshagiri Rao will remember that one of my favorites is Krishna Iyer. So I end, but this is the penultimate word. I end with this, with the last part being for Alpha Gen, of course. I end with some of his, he concurs with the majority in the Vaman Rao judgment. But he has written a small quip there, which is really critical, and it really places the, perspective on this doctrine. And he first starts with, Justice Holmes, and he says, I know he has said, don't be consistent, but be simply true. And this goes completely against Brandy's, what I talked about in the first instance, right? It's important to be consistent and not necessarily to be right. I, for one, am really glad that courts today understand that it's more important to be right than to just be consistent, and remedy wrongs which may have been perpetuated for a long time. And Krishna Iyer emphasizes that through the words of Holmes. And then he goes on in his, inimitable way to say, a foolish consistency is the hobgoblin of little minds, adored by little statesmen and philosophers and divines. With consistency, a great soul has simply nothing to do. He may as well concern himself with his shadow on the wall, right? And then he moves on to talk about what is so wrong about being misunderstood, and he goes on to talk about Pythagoras and Galileo, Copernicus, Socrates, etc., all of whom were misunderstood in their time, but then time proved them right thereafter, or at least we decided to adapt to them later. So he mentions this in the context that today what may seem wrong to you may not necessarily be so tomorrow, and therefore keeping your mind open to change may be critical, and his next statement kind of supports my interpretation of that. So he goes on to say, I may venture to speak, is that in constitutional issues, overstress on precedents is inept, because we cannot be governed by voices from the grave. I thought that was the most evocative statement I could have read from any of the judgments that I culled out and collated here. And that was a great statement to close out on, and therefore I used it here. And then he goes on to say, and it is proper that we ultimately right rather than be consistently wrong. That we are ultimately right. So he effectively overturns the Brandy statement earlier said, and that's why I started with that, and I wanted to end with this to show that. And he says that is the minimum price we pay for adoption of the jurisprudence of binding precedents. Enough unto the day is the evil thereof. And he goes on to say that you may not want to live with an evil always. So enough I have said. Why I said this is the penultimate quote I will share is, I wanted to close out with the risk, and because we have a lot of people, and I am often asked, why shouldn't courts use AI? And I'm all for everybody to use technology. We can't keep technology away from our lives, right? Lawyers use it, students of course use it all the time nowadays, and it's really difficult to explain to them what research is any longer. And then courts ask, why is it that only we are left to struggle? Why shouldn't we use it? And I always tell them, by all means use it, but it can only be the first step to fill a white space. It cannot be the final deciding arbiter for adversarial litigation, right? It can only be a first step. Now, when we are talking about the doctrine of stare decisis and AI, please think about the kind of harm it can cause And that's why I wanted to end with Krishna Iyer's words and that same caution when you use technology or overuse technology. So today, AI will read all the judgments that are there and tell you this is the outcome that is a probable outcome. And if you start relying only on AI to decide, then that judgment which is already there. So it is the perfect way for implementation of the doctrine of stare decisis, because AI is only going to read what is there and tell you. And the next generation then will be only judgments that are decided only on precedents. And AI is going to read those judgments and start believing that judgment which it actually decided is the perfect judgment. So you have then frozen law at a stage where there is no evolutionary process, whereas our lives move forward. Humans don't stagnate. We evolve and we move forward. And therefore, I end with this cautionary note. By all means, use technologies, but don't make it your final arbiter. And on the doctrine of stare decisis, if we do not have the right to evolve, if we do not evolve, if we believe that what has been decided is all that is about law, then what are we doing in courts? We are otherwise the shadows on the wall which Krishna Iyer spoke about, right? And we are certainly not shadows on the wall. We are all very, very live practitioners who understand the necessities of the profession. So let's enjoy this progress, let's enjoy the journey and evolve further and ensure that better and more substantial laws are implemented. Thank you all for having me here.
Thank you very much, Nappinai ji. Very extensively covered your today's topic. Your journey with our Friday group 2018 to 25, 8 years journey. From cyber law to cyber crimes to arbitration to today's topic. Corridors may be empty, courts may be empty. See, the Friday group is full.
Thank you. It's all thanks to your efforts. Sir.
Now I request Soumik Ghoshal will give a vote of thanks.
Good evening, group. Thank you, Sheshu sir, for this opportunity to give the vote of thanks, and thank you to the team and all the people gathered here. Ma'am, the topic for discussion today was so broad that one of the anxieties that I was facing is that what will be the takeaway for me home today. But I must say that even though our human mind is like in palimpsest, meaning every day we come across judgments and the older memories are rubbed off and new ones are made. But today you have done a phenomenal job of illuminating the various pressure points of all the important decisions which have taken place and the law laid down by our Supreme Court over the past years, starting from 1950 till today. Your emphasis on this doctrine took us not only through the Indian case laws but also the UK and the US case laws. You referred to Justice William Douglas's judgments, and those judgments in which he had laid down the foundation for later decisions like Roe versus Wade, like Griswold in Connecticut. Then you have also laid emphasis on some important Supreme Court judgments, the judgments which have been delivered by 13-judge bench like Keshav Nanda, as well as judgments by smaller benches but nonetheless very important ones. And lastly, you have been very candid and forthright in expressing your apprehensions like in the field of AI, and you have left us with an important thought that there is indeed a right to evolve, which is also maybe not a fundamental right, but it is a very important right, and therefore we should always be very circumspect in allowing AI to be used, because I think it is every lawyer's and every citizen's right to evolve and ensure that our judges lay down the law in an organic manner, and wherever there is a change required, that room should be left, which I feel a machine made or AI will always be lacking. With that, I thank you so much, and I thank the Friday group for this wonderful opportunity. Thank you so much.
Thank you, Sonik. So nicely expressed. And this is the talent we have. He was Andhyarjuna's junior once upon a time, topmost senior advocate of this country, constitutional expert.
And today is Sirvai's
I'm-
birthday also.